This is Boomer Life on CL 650.
It's a legal matter, baby. A legal matter from now on.
And welcome to the Law Show on CL 650. We're talking about personal injury. We have Kevin Hyde, partner at McQuarrieHunterLLP, and Neil Mulholland, associate counsel, based in Surrey, but covering all of the Lower Mainland, just like we do here on the radio. We're talking about going to trial and settling with ICBC. You can talk more about it, but from what I understand, a very small percentage of cases actually go to trial, and why that is important. Maybe, Kevin, you can talk about that.
Yeah, that's correct. It's a lot of people make that assumption that once they retain a lawyer, that means they're going to trial. That's not the case at all. The lawyer's job, and as the stats are something of like 97% of cases claims settled prior to having to go to trial. And
well, then people would say, well, why do I need a lawyer?
Well, you need a lawyer to put you in that stronger bargaining position. Mm-hmm. ICBC is going to treat you quite differently when you're unrepresented to when you're represented. You're clearly at an unequal position of bargaining when you really don't know what's going on. You don't understand Part 7s. You don't understand the tort, what your tort claim is actually worth, the various heads of damage, which we've discussed on previous shows, from loss of enjoyment of life and how to calculate that properly to loss of earning capacity, past wage loss, special damages, and so on. This is how we negotiate and bargain with ICBC, rather than when ICBC deals with lay litigant, they say, hey, how's $10,000 sound? Oh, just sign this release right here. And once that you sign that release, you're not only signing away, you can never go back. Or in very rare cases where you're under some kind of duress, and maybe you can go back, but it's very rare. You got to assume once you sign that release, that your claim's gone and your Part 7 benefits are gone as well. You could still be injured and you're on the hook for your own treatment from that point forward. But going back to your question, the types of claims that actually do go to trial are usually when it's a liability dispute. Who's actually at fault for this accident? It's a he said, she said with no independent witnesses there. So ICBC, might hold one party 100% at fault and the same party on the flip side and their claim 100% at fault. They'll do that at times. Or claims where there's very serious injuries that require a lot of experts and those reports that are done by the experts, whether it's the plaintiff's side or whether it's the reports on the defense side, and they conflict. Then those are ones that could potentially go to trial, or when a lot of money's at stake in a brain injury case or something of that sort.
Now, even the ones that are threatened and you have a court date set and it's a week away or a day away, the TV idea that it settles on the courtroom steps, does that happen?
It does happen.
It does.
It's a lot of posturing and it's a lot of preparation. So you've often won the day through preparation, and we do. And that preparation for a trial starts years before, from the day one that you come in and you sign up with us. We're starting to prepare for trial to put you in the strongest position possible, whether it's gathering all your clinical records, ensuring you're getting proper treatment, gathering your employment records, your T4s, to advance your potential loss of future earning capacity claim, getting all the documents and the witnesses in order for that. And then getting all the expert reports, sending you for independent medical examinations at substantial costs, which we cover for you completely to put you in that position of power. So when you're on the doorsteps of the trial, the courthouse, and that's a bit of an exaggeration. This often happens, in the month leading up to that trial is when the real serious offers come into the picture. But you're in the strongest position possible to get that fair settlement that you deserve under your insurance policy.
Now, Neil, when you have a law firm that is willing to go the extra kilometer in Canada. When you have a law firm that will do that and will go to trial and will take on ICBC, is there a ledger at ICBC law firms that do go to trial and those that do not, and they usually deal with you differently?
Absolutely. I mean, ICBC, as I say, is no different from any other insurance company. What motivates them is risk. In other words, if they look at a case that's set for trial, say, at the end of next month, they'll ask themselves, what are the risks that the judge is going to award this person more money than we've offered them? Mm-hmm. And if they see that risk as being fairly significant, they're going to up their offer to buy out of it. It's simply good business. They've got a trial coming up for 10 days. They're looking at paying their lawyers significant fees for 10 days of trial work, regardless of the outcome. Now, it is difficult for a lay litigant, a person representing themselves, to know how to put together a case sufficient to frighten an insurance adjuster. That's really what you have to do. You have to put the fear into them so that they understand that if they do roll the dice and take this case to trial, odds are they're going to regret the result.
But there are, from what I understand, there are some firms that don't go to trial that often.
That's right.
So
they don't put a lot of fear into ICBC.
So it's posturing, really.
In a sense.
Yeah.
I mean, in my practice, I typically run 1 to 2 Supreme Court trials on ICBC claims in a given year. That's been fairly constant for over a decade now. And I tend to be very careful about the claims that I pick for trial. Obviously, they're the claims that have the least amount of unpredictability to them. But the idea behind that is that I then produce a track record of trial results, which any adjuster can have a look at and immediately understand what I'm capable of doing. When you're, if you're counsel who does not generally go to trial, then the adjuster does not have that body of previous work to look at to sort of guide him in assessing the risks that he faces in going to court. He may look at you and think, well, this guy seems to know what he's talking about, but he's never run a trial. We don't really know if we have to worry about him all that much. And so, yes, in general terms, firms and lawyers that are known to proceed to trial more readily are going to get more dollars for the same injury.
That's a satisfying experience for your clients, knowing that you can, even if you don't go to trial, still get them more money.
Yeah. And in many ways, the 1 or 2 trials that I run per year benefit the rest of my clients.
So what other things can a lawyer bring to the table dealing with ICBC? So the threat of going to trial is there. Knowing what benefits are in your policy you've already paid for, not having to deal with the insurance corporation. And what other things?
Providing you that peace of mind that when that offer is out there, that is probably near to or is ICBC's top offer, that you get the peace of mind from your lawyer's advice and from our whole personal injury team's advice that is fair compensation for this type of injury, and it's probably not worth the risk of going to trial or moving forward. That you can go home and know that you were fairly compensated under your insurance policy. I
brought this up before because there's some big dollars at stake in many of these cases. To get your client to say, no, let's just wait a little bit longer when they know there's a substantial amount of money on the table. And for a lot of people who that might seem like a ginormous amount of money to them, and they say, let's just sign this and let's settle now. And you're saying, well, I think, in your line of work, you've seen bigger results. So how do you battle that constant human nature to take, like they say, a bird in the hand?
Neil and I had this situation just the other day on a claim that was going to trial, and they wanted to take that last offer. And what happened in this case is one of the experts couldn't be at trial, so we did a video deposition a week prior to trial of that expert. And our client said, you know what, I'm happy. I think that's ICBC's last offer. Let's not actually go to that next step of going to the video deposition, which is essentially the start of the trial. And we said, nope. We can pick apart this expert's report. We can put ICBC at more risk if we do this. And we did. We proceeded. We did the cross-examination of their expert on their report. And ICBC, sure enough, before that trial started, a couple of days later, threw another $25,000 on the table. And our client says, thank goodness I listened to you, because she did not want to listen to us. She said, I'm done with this. I'm happy with that money. I've talked to my family. Let's just be done and over with this. And we said, no, we're ready to go. Listen to us. We're the experts. And she said, thank goodness I listened to you.
And what Kevin was describing there basically is one of those fields where what we add in terms of value is that intuitive understanding of how the ICBC system, the personal injury system, tends to function. And that just comes with experience. Both of us having done defense work in the past, we have the benefit of knowing some of the adjusters that we're dealing with, having worked for them in the past, and that helps, obviously. It helps to build a good rapport and a good working relationship. But sometimes, I've often put it this way, so sometimes you can smell there's a little bit more money in their pockets. And sometimes I can't even put my finger on exactly what it is that tells me that there's more money in their pockets, but you can sort of sense it. And I've had several examples over the years where there's been a final offer on the table, sometimes in a mediation session where we've been bargaining for, say, 3 to 6 hours by that point. And the client is looking at it going, that looks fairly good to me. And I'm just looking at the faces across the table, and I'm looking at the history of what's been discussed in that last 3 to 6 hours in that room, and I think there's more there. And then knowing just how to get that out of their pockets. It's one of those things where you let your instincts take over.
It's a bit of a dance, right?
It is. And I've often found that, as Kevin pointed out in his example, there's been money there we didn't necessarily think would have been there.
Mm-hmm.
But
the resistant, how do you, it's human nature to say, that's a lot of money, it's going to change my life. I could get back to what I was doing before instead of protracting this out another 6 months. How do you resist that?
Well, you got to be very sensitive in that situation because, of course, your client has to fit your advice into their real life and their needs and so forth. And you have to take into account your client's appetite for risk. Some people are willing to pay a lot of money to go skydiving for fun. Mm-hmm. Personally, I'll jump out of a plane when it's on fire and not before.
Yeah, I say, why jump out of a perfectly good airplane?
There you go. So you have to understand, does your client have the appetite to take the risk inherent in going to trial? Mm-hmm. Some people simply won't. And there's no right or wrong answer to that. It's that they've reached the edge of their appetite for risk. That's it. Maybe there is more money there, but they don't want to risk not getting what's already on the table.
That's right. Yeah.
And ultimately, they are the client. And even if we give them advice that, hey, we think we should take the next step, if we do A, B, and C, we can get you more money, or maybe this is one that we would like to run to trial because we're confident we can get you more than this last offer that's on the table here. And the client says, nope, I want to take that last offer from ICBC. I do not want to go to trial, or I need the money now, or whatever their circumstances may be. We'll do our best to get the most money at that point. They tell us to settle because we're working for them. And we'll probably write you a letter confirming that our advice was to do A, B, and C, but you've given us instructions to settle. You sign that letter, we'll get you that money for you. Mm-hmm. But, in reality, the best clients are the ones, of course, that, leave it to us to tell them when that point to settle is and when our personal injury team has discussed your file and knows when it's time to settle.
And for what it's worth, I can say this in my own practice. In every single instance where I have advised a client to reject the offer and to carry on, we have done better. Mm-hmm. There has not been one case where...
Well, that's a good track record. Yeah. I'm sure a lot of people will be glad to hear that. Mm-hmm. Well, that's the voice of Neil Mulholland, Associate Counsel at Macquarie LLP, and Kevin Hyde is partner at Macquarie LLP. Thank you both for coming in and talking about a very interesting subject. And we'll have you back again another time right here on The Law Show on CL 650.